us. This is the February installment from the Houston Young Lawyers Foundation Fellow Committee. Starting this bar year, out of the HYLF Fellows Committee, we've been presenting a monthly CLE.
Right. I know I got to register.
You may need to mute somebody.
Okay. Awesome. Thank you for covering that, Miriam. I'm one of the co-chairs of the HYLF Fellows Committee this bar year, along with my partner in crime, Miriam Anna. So we have a very interesting topic here today, which we've been looking forward to for quite some time. We have two fantastic speakers. So we want to thank y'all for joining us here today. We enjoy CLEs, and it is great to see so many people join us that y'all enjoy CLEs too. So our first person on the panel is going to be Ben Ritz from Thompson Co. in the Houston office. Ben handles complex commercial insurance litigation and appeals, focusing primarily on insurance coverage in defense for primary and excess insurers, including complex multi-party insurance coverage and bad faith litigation involving general liability, environmental pollution, construction defects, directors and officers coverage, errors and omissions coverage, and property insurance. Ben is a Super Lawyers Texas Rising Star for 2024. And prior to joining Thompson Co., Ben served as a law clerk at the Southern District of Texas and as a briefing attorney at the First Court of Appeals. Every time I introduce Ben at a CLE, I am almost always saying Ben is the smartest lawyer I've ever worked with. So if you all have very difficult and complicated questions, please ask them to Ben and you will get an amazing answer. He is on my speed dial for whenever I have a complicated question. The second speaker that we have is Dominic Ruprecht from Reed Smith. Dominic litigates insurance coverage disputes exclusively on behalf of policyholders. He has recovered several $100 million for policyholders in the life sciences, energy, and manufacturing industries for a variety of claims, including environmental liabilities, cyber losses, mass torts, False Claims Act liabilities, and first-party losses. Dominic has been named to Best Lawyers in America for Insurance. And following law school, Dominic clerked for Chief Judge Kane of the United States District Court for the Middle District of Pennsylvania. These are two amazing speakers on a very interesting topic, so I'm going to stop talking and let them start presenting on the CLE. So Ben and Dominic, thank you so much for agreeing to present on this. We really appreciate you volunteering to talk to us.
Thank you. Let me get the screen share started. So do you, first, if you can be a double check for me that someone can verify that they can see the presentation.
You've got it.
Okay, awesome. So a reason we're here talking about insurance and sex trafficking is because this is a more recent area of litigation that's been more popular since we have the federal and state statutes that have been enacted starting in about 2000. And it's a very large industry, unfortunately, that has proven to be COVID resilient. So the first question is, of course, who are we talking about here? Who are the victims? Typically, they're minors. This is a slightly older statistic. I think ratio-wise, this is about 27%. Minors have gone up to about 36, 37%. So that's unfortunately been on the rise. They tend to be mostly women or girls, and they tend to be foreign nationals, usually brought in for promises of marriage and other promises of a better future. Once they're here, they're put into different services. Prior to COVID, the illicit massage, health and beauty was number 2. Now, possibly because of the online element, pornography is number 2. But of these different options that they might be pressed into service for, we're going to focus more on the escort services pornography angle, because that's mostly what you're going to find in the hospitality industry and hotel related situations. So other industries besides hospitality, just so you know, there are tech companies and there's certain rules around that and publishing, because a lot of the advertisements for these things are done online. Truck stops, also similar to hotels and hospitality. And more lately, security companies have started getting involved in these lawsuits, as we'll discuss later. In terms of causes of action, we see a variety of negligence causes of action: negligent supervision, general negligence, any flavor of negligence you can think of, they'll throw at it. There are federal and state statutes concerning sex trafficking, which we'll go over. There's RICO statutes. There's also tends to be internet intentional acts or conspiracy allegations. And so what I'm going to do is go over the federal framework and the state framework, and then Dominic's going to focus more on the coverage and insurance issues. So, and this is kind of a heat map of where it tends to occur. So let's say hypothetically, you have a client, they run a hospitality, run a hotel, motel. They had a situation about a year ago, they got cleaned up, they had a raid, there was some sex trafficking going on at their hotel. They claimed they had no idea. And about a year later, they call you up in a panic because now the victims are suing them. And they're like, can they do this? What's going on? How do we handle this? We didn't know anything about it. I think the janitor might have been a lookout, and I fired him. And I think he's being criminally prosecuted, but we didn't know. I mean, they paid with credit card, people were coming and going, but that's what happens at my hotel. So the first question behind door number one, we're going to focus on the Trafficking Victims Protection Act, which was first put into place back in about 2000 on the criminal side. And then in 2003, they created a civil right of action for victims who violated the criminal action. Now, the TVPA defines sex trafficking as recruitment, harboring, transportation, provisioning, obtaining, patronizing, soliciting of a person for the purposes of commercial sex, et cetera, et cetera. In other words, anything you can think of that deals with sex trafficking, they try to throw it in. It usually requires implications of force, fraud, or coercion. And also the statute provides whoever knowingly recruits and benefits from can be punished. Now, in 2008, they expanded the right of action to the victim to add a few more pieces. And this is on the civil liability side. And this is what we're looking at right now on the screen. It's whoever knowingly benefits financially or by receiving anything of value from participating in a venture which that person knew or should have known has engaged in an active chapter. In about 2023, they added the attempts or conspires to benefit language, although no decisions that I'm aware of focus on that. But I think it's easier to talk about in a more elementalized fashion. So if you want to break it down into three pieces that most courts tend to focus on, first is knowingly benefits. Second is participation in a venture, which is undefined in the civil statute, which creates a whole bunch of problems. And the last one is knew or should have known of trafficking. Typically speaking, numbers 2 and 3 tend to turn on the facts. The first one, the knowing benefit, tends to be relatively simple. In most situations, the knowing benefit tends to fall under the fact that they rented a room. So, oh, it does gestures. That's not good. So let's dive into the first case on one end. So MAV Wyndham is a good example of one of the cases on what's the circuit split on venture and knowledge, but usually focusing around venture because they kind of admix venture and knowledge. So in MA Wyndham, the allegation was sex trafficking occurred. This was in a Wyndham. There were some Wyndham Comfort Inns and Crown Plaza hotels. I blurred out the image a little bit. They alleged that the trafficker paid in cash for rooms near the exits for long stays. The rooms had lots of used condoms and other paraphernalia, and that MA in particular of the case had bruising and would not make eye contact. In fact, at one incident, she ran out and asked, and apparently she made a cry for help, and the hotel staff ignored her. In addition, online reviews of those particular hotels indicated that at least one guest was solicited for drugs and offered perhaps a sex opportunity. So in terms of a knowing benefit, we've already kind of discussed that, which is the fact they rented a room. So I'll move on from knowing benefits. So we're going to skip ahead to knowledge and come back to venture. So the knowledge tends to be knew or should have known. And basically that particular court found that those different facts were enough to allege that they should have known. To arrive at the decision, they looked at two different cases to kind of bookend. The one was Rico versus McLean, where they had a hotel owner witnessed a victim's abuse, clearly. And in fact, at one point, the hotel owner high-fived one of the traffickers in public. So that's on one end. On the other end, they had Lawson v. Rubin, where the victim alleged only one visit by the police and only one ambulance or condominium unit visit in like over 6 years. So between those two, the court in MA, the district court, held that signs should have alerted the staff. Now, the third element in participation of venture, they decided that all those facts together that we mentioned before established a pattern of conduct that the trafficker and the hotel had a tacit agreement. And while but the problem is that venture is only defined in the criminal statute. And that is defined as knowing, assisting, supporting, and facilitating the violation of another subsection. The civil statute, which is section 1595, does not define participation in a venture. But because they wanted to give meaning to every word, they wanted to make sure that they should have known language. So it's not just knew or should have known, because the criminal statute focuses more on knowingly. And they ultimately decided that that was enough to show should have known. So on the flip side, we have a series of Doe cases versus Red Roof Inns, mostly out of Georgia. And in that particular case, they went, and I'm just going to focus not so much on the facts of that case, but for time purposes on the venture element again. They did look at the criminal statute and defined it as assisting, supporting, and facilitating. And the court held that basically that because that they did require the finding of the criminal elements to be met, and since they didn't, the court dismissed some of the claims against some of the defendants. Now, this was appealed to the 11th Circuit, and they disagreed with the district court's finding of participation of a venture. They went back more similar to the Wyndham, but slightly different holding. The 11th Circuit found that the requirement of participating venture should be interpreted as plain meaning, which is to say that it needs to be framed in the form of a joint venture or a common undertaking or enterprise involving risk and potential profit, so more of a dictionary definition approach. But they did affirm the district court insofar as they felt that they failed to allege a common undertaking. Locally here, the 5th Circuit hasn't defined it, but the Texas cases that have ruled on the issue on the district court level tend to go with the way Wyndham, which is to say that they don't require a criminal finding. One of the effects of these various cases on the hospitality industry has been that a number of different associations, one being American Hotel and Lodging Association, other being the Asian American Hotel Owners Association, have started coming out with best practices for reporting or free electronic training they've sent out to their members to train staff on how to notice and recognize. And that these articles is relatively recent, at the end of 2023. A number of states, most states have put into place different laws that mirror or are very similar to the federal laws on the victim trafficking. But a number of states have also started to include requirements that hotel staff be trained to recognize human trafficking or have some training around human trafficking issues. For example, like Maryland, California, Connecticut, Minnesota, New Jersey, Florida, Iowa, North Dakota, Texas, and Illinois are there. Virginia and New York stated they were planning to add those requirements. I don't know if they have yet. So that's some of the effects of these changing rules. Now, behind door number 2, we're going to deal with Texas premises liability. Now, while I am focusing on Texas, because most of you are Texas practitioners, I do want to say that the same kind of foreseeability framework, albeit the factors may be different, the phrasing may be different. Most courts around the country do look at a similar kind of rubric to determine whether or not a particular premises owner is liable for whatever issue they're looking at. Most of these are not sex trafficking incidents, but this is the framework that's used to analyze this for premises liability, at least. So as you know, there's generally no duty to protect another person from criminal liability of a third party, but you do have to use ordinary care to protect invitees if you neither knew or had a reason to know of an unreasonable or foreseeable risk of harm. And so courts approach this either by looking at similar incidents or immediately preceding conduct. So the grandfather, at least in Texas, of these different cases is an apartment complex called Timberwalk, where they looked at a number of different factors, such as, how whether criminal conduct occurred near the property, which is proximity. What publicity was given to the instances that indicate the landlord should have known it, how recently that criminal conduct occurred, how frequently that occurred, and how similar those particular crimes are to the crime that we're dealing with at issue. In that particular case, it was not a sex trafficking case, but it was a sexual assault case. And evidence in terms of looking at those different factors established that there had been no violent crimes in the complex in the preceding 10 years. Only one sexual assault occurred within a 1-mile radius in the previous year, and the remaining 6 assault-type crimes in the neighborhood complex were not publicized or brought to the landlord's attention. So factoring those pieces into that rubric right there, the Supreme Court of Texas held that the sexual assault was not foreseeable. They later narrowed that in terms of another case called Trammell v. Crowe, which I'm going to skip over due to time, but essentially Trammell v. Crowe was a case that involved an actual hit on someone in a market, and whether or not certain crimes would rise to the level of predicating a murder, and they basically said no. However, there is at least a case on hotel property, which is Judge Alarm via DBA Comfort Inn versus Rhonda, where a motel guest sustained injuries for an armed robbery, kidnapping, and aggravated assault in the parking lot of the Comfort Inn. In the prior year, they'd had someone jumping on the hood of a car, theft of property, and theft from the register. They debated how far away to look from the hotel to determine the radius of violent crimes. But looking at those, they didn't feel that jumping on the roof of a car, theft, was sufficiently similar to robbery and kidnapping and aggravated assault. Now, moving on, we're going to talk about the immediately preceding conduct test. And this test is less likely to be used in the sex trafficking context, if only because they tend to be ongoing situations where someone is trapped for an extended period of time. But in terms of security claims, which are becoming more common now, and hotels often can sometimes have security, the immediately foreseeable situation comes up more often. So we also have a Texas Supreme Court case here, which is Del Largo. And Del Largo was basically a bar brawl. And the court essentially held that the nature of the premises, namely a bar, can make criminal activity, namely a drunken bar fight, foreseeable. The court found that the conduct immediately preceding the crime, which was repeated and aggressive confrontations between patrons about 90 minutes before the bar fight, should have put the premises owner on notice that something was about to happen. And they'll see this in a number of cases that I've looked at around the country in other state jurisdictions. They all will kind of look at, what was the content of the people in the bar, were they, what was the age and maturity level of them? What do they usually do in those contexts? In some sense, it's common sense, but basically, if there seems to be a clear and present danger of a fight about to break out, then that may trigger premises liability. Now, just real briefly, I'll mention some potential issue spotting that you may wish to do when you're assessing these kinds of claims. The first is superseding cause, which is a defense. And that's just looking to see whether or not you can put the blame on the criminal's actions as not foreseeable. Odds are that'll go back to one of the other tests that we were discussing. In terms of risk transfer, sometimes patrons will sign waivers, or you may have a contract with the security company, and that may or may not control some of the indemnity or risk transfer issues in the case, and so that may be something to inquire into. Same thing with franchisor relationships. If it's a named hotel, they might be a franchisee, and there may be a split when you get down to the motion to dismiss phase, a lot of times those cases don't dismiss the entire case. They may just dismiss the franchisor higher up because they don't control the day-to-day operations of the franchisee. And providing training may not be enough. Choice of law, always an issue, especially if you're dealing with trying to grab the franchisor in their insurance. Expert testimony is important, if only because there have been some cases, not in Texas, but elsewhere, like in DC, where if you don't have sufficient expert testimony or evidence to support what the standard of care should be, then it may kick out your case. Special relationships just deals with the good old-fashioned nature of, innkeeper's privilege or responsibilities, common carrier, ships, those kinds of things, because you could be on a cruise ship and have something happen or have a sex trafficking situation there. And depending upon the venue that you're in terms of whether it be a hotel or ship or whatever, may change the common law standards or even just normal standards of what kind of relationships they require. And then, as we mentioned, some hotels, especially if they're known to be in a higher risk environment, may wish to employ security. And depending upon how they go about that, how they go about advertising it, and so on, that may or may not be held against them later or not. It really kind of depends upon whether it makes the situation better or worse, or kind of provides evidence of new or should have known. And that's all at a very high level. So now we're going to go behind door number 3, which is the insurance world, because of course that's all well and good, but if we're dealing with a civil lawsuit, we always want to get coverage because oftentimes the franchisee hotel doesn't have the ability to pay the damages. Off to you, Dominic.
Thanks, Ben. Yeah, so is this covered? And, as a general principle, as I think Ben alluded to, it's unlikely that the true criminal enterprises, the criminal human traffickers, the cartels, whoever it is that's moving these victims across borders and committing the direct violations, are buying insurance. And frankly, difficult to imagine that you'd be able to get a judgment against them that you'd be able to collect on to the extent that the victims made a claim against them. So unsurprisingly, we see the individuals who've been victims of trafficking filing civil claims against premises owners, hotels, truck stops, whatever it might be. And when that happens, we look to insurance. So insurance has, the potential to play an important role in protecting these types of businesses that are, as a general matter, unwittingly participants in human trafficking schemes. And an important, point that I'd like to underscore when we talk about insurance for these types of cases, what we're dealing here with is liability insurance, third-party coverage. And so that type of coverage doesn't just protect the business itself. As a number of courts have recognized, in Pennsylvania with a Supreme Court case, Erie Exchange versus Moore, the benefits of liability insurance isn't just for the policyholder. It's to ensure that the victims themselves have the funds to be compensated. As Ben mentioned, a lot of these smaller franchisees are unable to pay a significant judgment. So insurance plays an important role. And kind of our first line of coverage that we look to when we think about insurance for business is CGL insurance, traditionally known as comprehensive general liability insurance, but now known as commercial general liability insurance. It's the basic type of insurance that businesses buy to provide for the defense and indemnification of third-party lawsuits. And the coverage grant has really 2 different coverage grants, I should say. The first coverage grant, coverage A, covers suits seeking damages for or because of either bodily injury or property damage during the policy period and caused by an occurrence. Coverage B provides coverage for suits seeking damages because of personal or advertising injury. It's a specifically defined term in the policies. You know, I think colloquially we think of personal injury as the same thing as bodily injury claims, but they're different. So the coverage A is what we look to for your traditional personal injury claim. Your slip and falls, you know, someone gets, you know, hit by a truck or whatever it is, where there's actual physical injury to the person. The personal and advertising injury is different. So it's a uniquely defined term in the policy, typically refers to things like defamation, copyright infringement, and then also relevant to these types of claims, false imprisonment and false arrest. Important hook for coverage is, again, these are liability policies. And so an important hook here is the duty to defend. Typically, your CGL coverages will have a duty to defend. Sometimes, although it's pretty rare that it would only have an obligation to cover or reimburse defense costs. But either way, there's a defense coverage component to these policies. Under Texas law and law generally, that defense coverage is very broad. If there is any potential for coverage within the four corners of the complaint or petition and four corners of the policy, there's coverage. If there's any doubt, the insurer must defend. If there's any one allegation that is potentially covered, the insurer has to defend the entire action. And there are significant penalties for the insurer that breaches a duty to defend, under Texas law at least. Texas law treats the duty to defend and defense obligation as a first-party coverage, which means that the Texas Prompt Payment of Claims Act applies. And so if there's a breach of the duty to defend, in addition to recovering your defense costs as a breach of contract, or right, the defense costs in the line action as a breach of contract damages, policyholder also gets 18% penalty interest plus regular interest, which I think currently stands around 8.5% plus attorney's fees. So it's a pretty large stick that a policyholder has to wage against its insurer. And so because that defense obligation is so broad, and because the penalties for breaching the obligation are so severe under Texas law, triggering the duty to defend for policyholders can create an incentive on behalf of the insurer to contribute to a settlement. And that's oftentimes the strategy that the policyholder counsel, and frankly, the underlying plaintiff's lawyers, the victims' lawyers, are trying to pursue when crafting their petition or complaint and when pursuing coverage. The goal here is to find pots of money to help compensate the victim for their injuries. And the duty to defend is a really interesting and powerful tool to do that. And so, again, we've got broad coverages under your CGL coverages, but exclusions that narrow the scope of coverage. So as an initial matter, I noted that for the Side A coverage or coverage A, the policyholder needs to establish an occurrence, which is an accident. Corollary to the occurrence issue is the expected or intended exclusion. The lines do tend to get blurred a little bit between those two exclusions, but the occurrence requirement for coverage and the expected or intended exclusion. But as a general matter, where the insured either expects or intends the injury, coverage is barred, either as under the expected or intended exclusion or the occurrence definition. And negligence is typically treated as an occurrence, with the benchmark being, did the policyholder actually intend to cause the resulting harm? So typically in our petitions that we see when the victim is attempting to plead into coverage, we see lots of claims of negligence. And that's, again, as I said, we have the hook for the duty to defend as long as there's one negligence claim in there. Policyholders, lawyers are going to argue that provides coverage for the entirety of the lawsuit, even if there are additional claims asserted. Now, there are additional exclusions that create more challenges to coverage, and they're listed here on the slide. So the first exclusion, or I guess the second exclusion listed on the slide, is the criminal acts exclusion. We see these pretty standard in a CGL policy, and it bars coverage for damages and claims arising out of a criminal act committed by or at the direction of the insured. Important to remember, the Texas Supreme Court and other courts around the country interpret arising out of incredibly broadly. It's just but for causation. If there's any relationship between the criminal act and the claim, exclusion's triggered. And so, where a complaint is asserting only criminal liability or only liability that's arising out of criminal acts, that exclusion at least potentially comes into play. An interesting example of how that exclusion is applied is a case from the Massachusetts Federal District Court in Riccio. It's a case decided on a duty to defend in a lawsuit brought by victims of human trafficking, alleging criminal violations of the Trafficking Victims Protection Act. Unsurprisingly, given that the lawsuit pleaded, and in fact, in this case, it only pleaded criminal violations of the Trafficking Victims Protection Act, the court still held there was a duty to defend. And that's because the TVPA permits recovery under a civil standard, even the absence of a criminal mens rea. And the court, again, applying this very, very broad duty to defend standard, which really mirrored the Texas standard, held that because the claims were reasonably susceptible to the possibility that there would be a covered claim for civil negligence, in addition to the various criminal claims, because it was possible that the policyholder could have been held liable solely based on civil negligence, the court held there was a duty to defend and coverage was triggered. So again, it shows the interesting interplay on a duty to indemnify. The case might come out differently, but at least for defense costs, that criminal acts exclusion gives some flexibility to the policyholder. Assault and battery exclusion it's not a standard exclusion in every policies, but frequently, and certainly more and more, we'll see it coming up in policy forms as endorsements issued to clients in the hospitality industry and elsewhere. That exclusion applies to claims arising out of assault or battery, and it applies regardless whether or not the assault or battery was committed by you, caused by you, regardless of intent. It's a really challenging exclusion. A case that dealt with that exclusion is the Nautilus case versus hotel management, Eastern District of Pennsylvania case that was affirmed by the Third Circuit. In that case, it was, again, as we see it in many of these cases, it was a lawsuit by victims of human trafficking against a motel owner. There was no suggestion that the motel owner was engaged in any assault and battery, no claims of criminal acts by the motel owner. The claims really were primarily based in negligence. Claims were that the motel rented a room to the woman's attacker and failed to prevent harm. Again, relying on that very, very broad arising out of language, and coupled with the lack of any requirement of intent or culpability by the owner, despite the fact that the motel owner didn't actually engage in that wrongful conduct, because the victim's claims arose out of the wrongful conduct committed by others. the exclusion kicked in and coverage was barred, and the Third Circuit affirmed that exclusion. So again, shows that where you have this policy language that is untethered to the acts of the insured, coverage can get very, very challenging. I'd note that there's, kind of conflicting, might not be the right word, but there is, other authority, certainly in Pennsylvania and elsewhere, clarifying that the policy needs to be explicit when you want an exclusion to apply, when you want a conduct-based exclusion to apply, regardless of whether the insured is the entity committing the wrongful act. So here, I would expect, based on, and they were applying Pennsylvania law there, if the exclusion had been written differently, and so it was only arising out of alleged assault or battery, not arising out of assault or battery, whether or not committed by you, exclusion might not apply, case might come out differently. And so that's just underscores the importance of really looking carefully at the exclusions and not seeing a very broadly worded exclusion, just assuming there's no possibility of coverage there. And I think, frankly, the next exclusion we're going to talk about, the abuse and molestation exclusion, is a really good example. And there's some conflicting case law on this that really underscores that point. Again, it's not a standardized exclusion, but we certainly see it appearing with increasing frequency in policies issued to insureds in industries that are impacted by human trafficking via endorsements. And there's two different cases that we can talk about that underscore how the different wordings of these exclusions can lead to differing outcomes. So Miller's Capital versus Annal of Assant is a Maryland federal district court case. And that was a sex trafficking claim against an econolodge, asserting, again, as we typically see in these types of cases, a negligent premises liability claim. In that case, the abuse and molestation exclusion barred coverage for injuries arising from, again, that broad arising from language, the actual or threatened abuse or molestation by anyone, of any person, while in the care, custody, or control of any insured. So there the court held the exclusion didn't apply. The court did look to the kind of really broad arising out of language and held that, yes, no question, the negligent premises liability claims against the econolodge certainly arose out of sexual abuse. And so that first part of the exclusion was triggered. However, even though the claim arose out of abuse, the court held the insurer couldn't establish the care, custody, or control requirement. The reason being, the undisputed facts show that the econolodge owner wasn't actually aware that the victim was in the motel room. And so the court reasoned that if the owner knew or didn't know that the victim was even on the premises, the court held that the insurer couldn't establish care, custody, or control of the individual. And so, again, because exclusions must be strictly, narrowly construed in favor of coverage against the insurer, the court held in that case that the exclusion didn't apply. Case that comes out differently based on slightly different policy language is the Pillagra versus America's Best Value In claim, or case from the Louisiana state courts. Similar claim, similar theories of liability, and there the exclusion was actually silent on the care, custody, or control requirement. And because the exclusion did not include that same language, the court held the exclusion applied because based on the plain reading the policy, a plain reading of the exclusion, the court held that it arises out of sexual abuse and therefore there is no coverage for these claims. Again, I think that case likely comes out differently under Pennsylvania law, where we have some good authority, at least good for policyholders, that holds where if you want a conduct-based exclusion to apply to the conduct of third parties, the exclusion has to expressly say that. And we have cases making that point in the context of abuse and molestation exclusions. We also see it in exclusions for professional liability. So there is conflicting case law out there on the Peligra outcome, but again, comes back to this is, the policy language matters, and potentially Texas, the way Texas courts view and really kind of strictly construe policies. A Texas court might come out the same way as Louisiana. So it's a again, interesting difference in the way these cases come out based on the different policy language, and really underscores again the importance of the choice of law and choice of forum with respect to these claims. So once we get through all the different hurdles of coverage, do the four corners of the policy and four corners of the petition or complaint match up? The insurers have another backstop, and that's public policy. These are obviously challenging cases. They are, if you read these petitions and complaints, I mean, it rips your guts out what's happened to these individuals who've been the victims of human trafficking. Coming into court saying you want insurance coverage for those types of claims is incredibly challenging. And, courts typically, even if, you can say with a straight face, I had no idea this was going on. No one wants to be a judge who says there is an insurance coverage for human trafficking, sex trafficking, some of these horrific underlying facts. And in fact, that's exactly what some courts have held. And a good example of the complexity of these issues is a case from the Eastern District of Pennsylvania, and which is actually currently on appeal to the Third Circuit. The case is Samsung Fire and Marine Insurance versus UFVS Management. It's actually a case handled by Reed Smith, so I'll do my caveat of saying I am not a counsel of record in the case, and so nothing I am saying should be treated as an argument of any party or anything else. And trust that this will all disappear with the rest of you. But so in Samsung, the claims were against the owners of a Philadelphia hotel where sex trafficking had occurred. 4 different complaints kind of consolidated into a single coverage action. The district court, in reviewing the parties filed cross motions for summary judgment on the pleadings, complex dismissal motions, and all sorts of different things. But at bottom, they filed a very early motion for judgment on the pleadings. Judgment as a matter of law. The court, in reviewing the competing motions, decided it wasn't even going to look at the language of the policy. The court decided the question of whether there is the potential for coverage with respect to the duty to defend these lawsuits solely based on public policy as a matter of law. Said, as a matter of law, this is such repugnant conduct. The underlying criminal activity is, so shocks the conscience. And to be fair, the underlying criminal activity certainly was shocking and would shock the conscience, that the claims were barred as a matter of Pennsylvania public policy. It raises some interesting policy questions. Obviously, I think everyone understands why the actual traffickers and the people who were directly involved in the criminal activity and were alleged to be intentionally engaged in that activity shouldn't get insurance coverage. The question presented really here was, should the negligent hotel owner who doesn't know what's going on in the rooms be entitled to insurance coverage for these types of claims? Important to remember, these are, again, duty to defend cases. The traditional formulation of a duty to defend claim is that the insurer is, obligated to defend even if the underlying liabilities are groundless, false, or fraudulent. And so the question that is raised in my mind as a policyholder lawyer is, well, what if these allegations are false? Is public policy really served by refusing to even allow for the defense of potentially groundless negligence claims? Eastern District said yes, and it's currently on appeal to the Third Circuit. And the Third Circuit, I think, is where these public policy questions get really interesting, because the underlying victims actually filed amicus briefs, and they filed amicus briefs on behalf of the hotel. And so the amicus argued that, and when I say amicus, the victims here argued that the hotel should be entitled to insurance coverage for these liabilities. They argued the district court conflated the act of human trafficking, which is obviously criminal and repugnant, with the locations where the human trafficking occurred. They emphasized they never accused the insured of actually engaging in intentional criminal conduct, and their allegations were negligence-based, and that the district court was required to accept those allegations as true for the purposes of evaluating coverage. And they closed by noting, and I think this is really the key, that cutting off coverage in these types of cases really imperils the ability of the victims to obtain just compensation for these horrible things that have happened to them. And that's really, again, the key here. And that's where I kind of started my discussion of the insurance coverage and the Pennsylvania Supreme Court decision, Erie versus Moore. Erie versus Moore, by the way, it's an interesting case. It's a case where the policyholder, I guess it's homeowners insurance, where the policyholder intentionally went and intended to kill his ex-wife, and in fact did go to his ex-wife's home and shoot her and kill her. And in the process of that, he accidentally shot his ex-wife's new lover, severely injuring him, and then he killed himself. And there it was an expected or intended injury exclusion, a public policy defense, and the Pennsylvania Supreme Court said, yeah, this is bad, but and so certainly no coverage for the intentional killing of your wife. But the Pennsylvania Supreme Court said that public policy isn't served by barring insurance coverage for injuries the insured didn't directly intend. That you're not really going to, by having an avenue to compensate the victims for those types of unintended injuries, isn't going to make the insured any safer, any more protective of third parties. He was still going to go try and kill his wife. And so cutting off coverage in those circumstances really only has the impact of hurting the victim. In the Moore case, it was the unintended person who was shot. And potentially, in the Samsung case, we'll see how the Third Circuit comes out, it's the unintended victim, which is the individuals who were trafficked. And so, again, the district court didn't buy that argument, but it'll be interesting to see what happens at the Third Circuit. I see we're running low on time, so I'll just note that there's certainly a number of other cases out there dealing with these really complicated and complex public policy issues, including there's a broad swath of cases dealing with it in the context of abuse and molestation with clergy abuse and similar types of cases. So those are kind of the big picture policy issues. I think the takeaways are, these are complicated issues. It varies pretty broadly based on policy language and based on public policy considerations. But Ben, I'll toss it back to you to kind of sum up our kind of key takeaways here with respect to these liabilities.
Okay. Well, as we mentioned before, the federal statute kind of set the trend, which is focusing on whether benefit. They rented a room, usually don't have to worry about that. And whether they knew or should have known, based in the context of two, whether it was foreseeable. And that's going to vary based upon the frequency of crimes, location of crimes, the types of crimes, and so forth that are in the area. Usually not the immediately present one, but that might come up in more recent security cases. Dominic's covered the different ways, the two different coverages A and B, that could potentially be triggered under your typical commercial general liability one, as well as discussing different avenues that insurance companies might use in terms of exclusions to try to argue against either a duty to defend or the ultimate indemnity. And I'm not going to repeat them here because we cover them in detail. And that is our talk. I want to save a few minutes for questions in case there are any. And there may not be, but so this is as we were discussing yesterday, this is a Brady Bunch style format, meaning that the people on the call can jump in if they want to. And
Hey, thank y'all for the presentation. I've got a 1 o'clock appointment on Zoom call I need to jump on, but I appreciate it very much.
no
Thanks,
problem, Mark.
All right, y'all take care.
You too.
Thanks.
Questions from anyone else? I guess I can stop the screen share. Nope. There's a chat thing. Okay, just a thank you. Okay. So it looks like a lot of the participants are muted. If there's anybody who wants to speak, I guess you could raise your hand and Daniel could unmute you if you'd like. And any kind of questions about the basic framework or how to plead yourself into coverage, which is always important because especially if you're plaintiff side, you always want to make sure that the insurance is involved.
Ben and Dominic, I have to get off for a 1 o'clock meeting, but want to thank you guys for a really interesting presentation, and especially as a plaintiff's lawyer touching on pleading into coverage. I really appreciate that part of the program, and thank you, Daniel and Marion, for setting this up. I really appreciate the work you guys have done, and Dominic and Ben, thank you again for your time.
Yeah, thank you.
Yeah, this was a fantastic presentation. Thank you both so much for this presentation, volunteering your time to teach us some things. We always love learning. So y'all are working on some kind of publication on this kind of topic, right?
Yeah, we're revising a white paper that we intend we have a conference next week where we're doing a roundtable on the same topic, but to people who are more focused in the insurance industry. But it still has some of the same material that we covered today. Okay,
excellent. It does not look like we have any questions that are coming in on the chat that I've seen, at least. So I guess I want to say thank you to everybody that has joined us here today. We really do appreciate you coming out to support the HYLF Fellows Committee CLE initiative that we have this year. The person who got us the MCLE accreditation is not on the call, so I do not have the CLE number for everybody. We will email it out after the presentation, just as soon as we have it. We unfortunately do not have it right now.
I know Lucy would always like us to take a picture if you didn't already grab one, but
yeah, I did not. That is a good idea. We should do that.
One with the three of us, and then if anyone else wants to join us in the picture, you're welcome to do so.
Yeah, let me